The average person agrees to thousands of legal contracts in their lifetime, employment agreements, software licenses, rental leases, and reads almost none of them in full. That's not laziness. It's information overload engineered by design.
Today, we demystify legal English, not to turn you into a lawyer, but to give you the tools to read, ask about, and push back on legal documents with confidence.
Welcome to Advanced English in Context. Legal English is a register unto itself, formal, arcane, and full of Latin phrases, passive constructions, and conditional clauses stacked upon each other.
At C1 level, you may encounter legal documents in job offers, business partnerships, or property transactions. Understanding what you're reading and knowing what questions to ask is a genuinely high-stakes skill.
Conversation 1. A lawyer explaining a non-disclosure agreement to a client. Conversation 2. A freelancer negotiating a contract clause with a company's legal team. Conversation 1. I'm a solicitor named Rebecca. Sarah, you're my client. Tom, a software engineer who's been offered a job at a tech startup.
Rebecca, I've gone through the employment contract and there are a few clauses I'm concerned about, particularly the non-disclosure agreement attached to it. The scope seems very broad.
You're right to flag that. NDA scope is one of the most commonly overlooked elements in an employment contract. Can you show me the specific provision you're concerned about?
Clause 14.3. The employee shall not disclose, directly or indirectly, any information pertaining to the company's business, operations, technology, or clients, whether or not such information is designated as confidential. That covers everything.
That is extremely broad, and in many jurisdictions it would be considered unenforceable precisely because it doesn't delineate what is and isn't confidential. A well-drafted NDA should include a materiality threshold.
So I could push back on this without jeopardizing the offer?
Absolutely. You'd propose a narrower definition, something like, confidential information means non-public information specifically identified as such in writing at the time of disclosure. That's standard in well-negotiated contracts.
What about the non-compete clause? It says I can't work for a competitor for 2 years within a 100-mile radius. That feels excessive.
2 years is at the outer edge of what courts will typically uphold, and the geographic restriction is arguably unreasonable for a software role, where work is increasingly remote. I'd push to reduce both to 6 months and remove the geographic element.
And if they push back?
Then you negotiate. Counter with 12 months, no geographic restriction, and a carve-out for companies where your primary role wouldn't involve direct competition. That's a reasonable middle ground that most companies will accept.
This is incredibly helpful. I had no idea I could negotiate these terms. I assumed the contract was take it or leave it.
Almost nothing in a contract is truly take it or leave it, especially for skilled professionals. The language in a contract is a starting point for negotiation, not a final edict.
Let's break down the legal vocabulary. Provision in everyday English. A provision is a supply of something. In legal English, a provision is a clause or condition in a document. Know both uses.
Unenforceable. A contract clause can be legally invalid even if it's an assigned document. Courts can strike down provisions that are too vague, too broad, or that violate public policy. Knowing this gives you power.
Carve-out is one of the most useful terms in contract negotiation. When you carve out an exception, you're saying, this rule applies except in these specific circumstances. It's a surgical precision tool.
And edict, from Latin, meaning something proclaimed. In modern English, it describes any pronouncement issued without expectation of discussion. Using it to describe a contract clause signals that you recognize the power dynamic involved.
Conversation 2. A freelance designer negotiating a project contract with a company's in-house legal team.
Good morning. I've reviewed your standard contractor agreement and I'm happy with most of it, but I have 3 specific points I'd like to discuss before signing.
Of course. We're always open to reasonable discussion on the terms. What are your concerns?
First, Clause 9 assigns full intellectual property rights to you upon delivery. I'm fine with the work I create for this project, but I want to retain rights to any pre-existing tools, frameworks, or methodologies I bring to the engagement.
That's a standard concern and we can accommodate it. We'd amend Clause 9 to distinguish between bespoke deliverables created for this project, which you assign to us, and background IP, which remains yours.
Perfect. Second, the payment terms say net 60. For a project of this scale, that's a significant cash flow strain. Could we negotiate net 30 or a milestone-based payment schedule?
We typically work to net 60 as a standard, but given the project size, I can escalate a request for net 30. Alternatively, a 30% upfront payment with the balance at delivery might work for both sides.
The 30% upfront option is actually very workable. Third, and this is the big one, the indemnity clause at Clause 17 holds me personally liable for any losses arising from the deliverables, without a cap on damages. That's an unreasonable risk transfer.
You're absolutely right that an uncapped indemnity is unusual for an individual contractor. We can add a liability cap equal to the total contract value. That's a proportionate and standard approach.
That's entirely reasonable. I'm glad we could work through this directly rather than going back and forth through intermediaries. Let's get the revised terms in writing and we can move forward. From the second conversation, background IP. Intellectual property has two categories in contractor agreements: foreground IP, which is created for the project, and background IP, which the contractor already owned. Always protect your background IP.
Indemnity clause: to indemnify means to compensate for loss. An indemnity clause in a contract determines who pays when things go wrong. An uncapped indemnity for an individual is genuinely dangerous. Always negotiate a cap.
Risk transfer. Every negotiation involves distributing risk. When a company uses aggressive contract terms, they are transferring risk to the other party. Naming this is powerful. This clause represents an unreasonable risk transfer.
Cash flow strain: even profitable businesses can fail due to poor cash flow timing. Net 60 means payment 60 days after invoice. For freelancers, this creates a gap between work delivered and money received that can be genuinely destabilizing. Slow repeat. First, the language in a contract is a starting point for negotiation, not a final edict. This is a mindset-shifting sentence. Learn it and use it.
Stress. Starting point for negotiation, not a final edict. Full speed. The language in a contract is a starting point for negotiation, not a final edict.
Second, the indemnity clause holds me personally liable for any losses arising from the deliverables, without a cap on damages. This is technical language. Practice it until it sounds natural.
Slow. The indemnity clause holds me personally liable for any losses arising from the deliverables, without a cap on damages. Full speed. The indemnity clause holds me personally liable for any losses arising from the deliverables, without a cap on damages. Quiz. Question 1. The solicitor said a broad NDA might be unenforceable. What does this mean for a signed contract? A. The contract is invalid entirely. B. That specific clause may not hold up in court. Or C. The company cannot use the contract.
Answer: B. A specific clause can be unenforceable while the rest of the contract remains valid. Courts can strike out individual provisions without invalidating the whole agreement.
Question 2. What is a carve-out in a contract? A. A section that has been removed entirely. B. A specific exception to a broader rule. Or C. An additional clause added at the end.
Answer: B. A carve-out is a deliberate exception built into a broader rule. It allows you to say, this applies to everything except this specific thing. It's a precision legal tool.
Legal documents are intimidating by design, but they're negotiable, they're challengeable, and they're readable once you have the right vocabulary. Today you've built that foundation.
Subscribe and join us next time for a conversation at the frontier of technology, artificial intelligence, its opportunities, and its risks. English 064 awaits.